Hello, everyone. Welcome to Court Chatter Live, to our special verdict edition of the Ross Harris hot car death trial. We are, was a long time coming, right? 2 years ago is when this all started. 2 years ago in June. And now, yesterday, a verdict came down. We tried to do this show for you last night. My internet went out, and it was out for 7 hours. So don't want to talk about that right now, but we're up and good and we're going tonight. And I have Phil here. I'm going to bring in my guest, Phil Holloway. And for those of you who are not familiar with him, he is a practicing attorney in the Atlanta area. He's also a former prosecutor, former police officer. He's done it all, and he knows everything there is to know about this case. He also knows all the parties involved in this case on both sides except for the defendant, but knew the judge, defense attorneys, and the prosecutors. Welcome, Phil.
Hey, great to be here.
How are you tonight?
Well, I'm happy to be here. I'm glad that there is a conclusion to this case. Obviously, it's a very sad story, no matter how you slice it. But I'm glad that the process has finally run its course.
Yeah, I think we kind of all are. And what I always talk about with the trial watchers is the rest of us are kind of in postpartum depression, but we're in post-verdict depression. We're not quite sure what to do with ourselves. And there's a couple other cases going on, and we're still watching the Michael Slager trial, but it's just not quite the same. So I'm glad that we're at least doing this show so we can get some more of our thoughts out there. So I would actually just like to go ahead and start by playing the clip of the verdict. So in case anyone out there didn't catch it, to see his reaction. Now I'm just the first two top counts, which in my opinion were the biggest shockers, if there were any shockers in this. Let me get this up and ready to go here.
The jury find as follows: count one, malice murder. As count one, you find the defendant guilty this 14th day of November 2016. Count four person. Count two, felony murder. As count two, we find the defendant guilty this 14th day of November 2014. Count one, four person. Count three, felony murder. As count three, found the defendant guilty this 14th day of November 2016.
Okay, so I'm not sure how the volume worked on that. Now I probably have my volume way up. My moderators will have to tell me how that's sounding now. The volume wasn't very good basically throughout the whole trial. Oh, good. Okay, Red says she heard it loud and clear. Okay, so that was his reaction to the top counts, the malice murder counts. He didn't have any reaction to the top counts. I thought he'd have something to the malice murder. Just really quick, I'll give my opinion. If you haven't already heard it in the previous shows, I didn't think he'd be found guilty on the malice murder charges. I thought hung jury. I didn't think he'd necessarily get not guilties. I just didn't think they would get 12 people to agree to the malice. I thought it was a very hard thing to prove. And look, I've gotten a little bit of hate mail, so I'm just saying it's not that I like Ross Harris. It's just that I just want to know what they proved legally inside that courtroom. And I just didn't think that it was a strong case for malice, in my opinion. So I was a little shocked by the top two counts and that they were unanimous on them. I wasn't shocked at the rest running down the board. So give me your thoughts on it, Phil.
Okay, so, you know, it was almost, not quite, but almost like when I have my own trials and you're sitting there and you're on pins and needles, right? And you're waiting on the jury to give its first verdict on the very first count. When I heard guilty on malice murder, I knew that it was guilty on everything else, right? Because, I mean, that was, we all agreed, the hardest thing to prove. With the absence of a smoking gun or a confession, they had to cobble together proof of intent by circumstantial evidence, which can be viewed differently by different people. And to get 12 people to unanimously agree in really only 3.5 or so days was quite remarkable. So I was a little surprised that it was guilty so quickly. There was good arguments made by both sides. And, I say this case is historic, and I say that for this reason. Never before in the history of American law, as far as I can tell, has a father or anybody ever been charged or convicted of murdering a toddler in this fashion. And if it was intentional, how heinous and horrible a way to kill your child. So it was historic, but there's going to be an asterisk beside this because people will always, I think, have some residual doubt about whether or not he really did maliciously, intentionally kill that boy.
Absolutely. I mean, how many hot car deaths have we seen since this case? Now, there I'm sure were a lot before this case, but now the public awareness of it is crazy since this case. And we are hearing about it all the time, which is so unfortunate. But nobody's getting charged with malice murder.
No.
I mean, this is incredible. It's incredible that they firmly believe. And while we're on that, I will read what Chuck Boring has to say about what they firmly believe. He says, in every turn it was something. Okay, that doesn't make sense. That doesn't apply. That doesn't apply. Everything, at every turn we got to was showing us malice. But even in our world, you don't want to believe someone is capable of this. I really think that he in no way thought anyone would call BS on him. So that was from prosecutor Chuck Boring. That's what they believe. They believe he wanted Cooper dead and to kill him in that manner.
And if I had to guess, I would say that the prosecution team thought from the very beginning that it's so counterintuitive that a parent would kill a child in this way, and that it may be very difficult for someone to get their head wrapped around that. That's, if I had to guess, I'd say that's a good part of the reason why they didn't seek the death penalty. Because if you think about it, assume for the sake of this discussion, the jury got it right, and he is, as a matter of fact, guilty. What better case for the death penalty than this one, if it was in fact malicious? So if you're the prosecutor and you decide not to seek the death penalty, what that suggests to me is that you are aware that human beings like us, like those of us who are watching this trial, sometimes have a hard time wrapping our brains around this concept that someone could be this evil on purpose.
It's, maybe some of that is what clouds my judgment in this case, although I really try and be really open to the evidence because it's so unbelievable. It's so unbelievable to kill. It's unbelievable to kill your child, period, end. Then it's so more unbelievable in my head to do it that way. I mean, it's just such a, okay, let's say you're a cold-blooded killer. Let's say you want to kill your child. How many things could go wrong with that manner, to do it in that way? Someone's going to walk by and see him. It's not going to get hot enough. I don't know. I know people say he knew about it and he did some research on it and all of that. But if you're going to kill your child and you want it done, this seems like a very risky way to do it.
Yeah, there's no question about it, because in that particular parking lot, there was security cameras all over the place. And if in fact the prosecution is correct in what they said yesterday, and I apologize if I'm confusing the press conference from closing argument, but I think they also said this in the press conference that they think it was something that, he kind of just, light bulb went on at Chick-fil-A and he said, now's the time, I'm going to go ahead and do this. This is something that I'm aware of. And now's the perfect time for me to go ahead and get my escape. And they just didn't really think it out. I think that may be what the prosecution's theory is. At the end of the day, nobody knows what was in Ross Harris's mind except Ross Harris.
That's right. That's exactly right. And look, hey, the jurors think that he intentionally did this, and he very well could have intentionally done this. Nobody knows what's in his head. And
another thing that we don't know, and I'll apologize for cutting you off, there's a lot of stuff that was in the jury room that we didn't see on the screen and on the live feed, and they have a lot of physical evidence with them back there in the jury room that they could have read through, things that really did not get played, so to speak, for the cameras. So that's another piece of this equation that we can't really forget about, is that they had access to more than we actually saw.
That's right. And Julie in the chat room says, people who kill don't think they're going to get caught. He thinks he's smarter than everyone else. And we do know that about killers. So if Ross Harris truly is a cold-blooded killer, we already know that you can't predict them. And they do think they're smarter than everyone else. And they do think they're going to get away with it. Okay, I was going to read, I read what Chuck Boring had to say and what defense attorney Max Kilgore has to say. You and I talked a little bit about how upset he was in the press conference afterwards and visibly upset. But he said, this is what he said to a reporter after. I want you to know that we met with Ross in the back room afterwards. He wanted to talk about Cooper and how much he missed him. He wanted to console us. Said they sat with him for nearly an hour after the verdict was read, the four of them praying and sometimes weeping. Interesting that they had gotten so, I mean, is that, Phil, you're a defense attorney. Is that normal to get that involved in your client's case and to be that emotionally attached?
Well, you typically strive to keep some type of a clinical distance, and that way you stay objective. Excuse me, they're all human beings, and apologize. These lawyers on both sides have been working on this case, living with it day and night, 7 days a week for over 2 years. And they have literally put their heart and their soul into their efforts. And yes, I think Mr. Kilgore's beliefs are genuine. From the very beginning, each side of this has felt 150% that they were correct. The prosecution has always felt it was intentional, no doubt about it. And the defense has always said, no, it was an accident, no doubt about it. And that's one of the things that I find so amazing about this is that, normally lawyers, when we talk around the courthouse and, hey, you got a trial going out today. Yeah, you got a chance of winning it. Yeah, maybe a small chance, but we're probably going to be going down in flames, and then, that's just kind of the way things are in the real world. But in this particular case, it wasn't like that. Each side said, no, we guarantee, that we got this right. And so you just had these positions that were staked out, that were so far apart from the very beginning that this case had to be tried. Some jury somewhere had to decide it, and they did. Yeah,
they did. Okay, Raylene has a question about what one of the jurors, now, the jurors haven't spoken to any media, so they met with the attorneys after. So we just heard filtering through the attorneys what the jurors said. And apparently one of the jurors said that they had the significance they saw in the video they asked to watch of him going to his car at lunchtime. We all thought, and it still could be, that the real significance they were looking for was him walking away from the car, going back to work. As he passed that other passerby, he stopped and paused. We thought they really wanted to look at that interaction, and they may have. But this juror talked about him putting the light bulb, opening the car with the door with his left hand, and throwing the light bulbs in the car also with his left hand. And that was a significant point to them, although they didn't elaborate on why that was significant. So you and I were trying to briefly discuss, like, why is that significant? The left hand and the left hand. I mean, my first thought was because he probably had his phone in his right hand. He always had his phone, always. So, but something about that struck at least one juror, if not multiple jurors.
Right. And I think, Chuck was put on the spot by a reporter who asked him for a specific example, and that was the first one that came to mind. I really don't know what significance it would be, what hand he used. Maybe he was left-handed. I really don't know. Does it matter? To me, I wouldn't think that it mattered what hand he would use to open the door.
I mean, I was trying to think about it. Like, does that mean because he was twisting, and so you're twisting to see if you could see Cooper, sort of? I mean, is that what they were looking for?
Suppose anything's possible. They did get to walk around that car. They got to look at it up close, and maybe one of them was thinking, well, if I use my left hand to open it, it's going to cause me to look to the right a little bit more. And I keep going back to two things, really. First is the close proximity of the car seat to the driver's seat. In other words, where Cooper's head would be in relation to Ross Harris as he's driving down the road. So it was very, very close. Whether you measure from the shoulder or the headrest or wherever, it's still a matter of 3 or 4 or 5 inches at the most. And so you got that fact with Mr. Harris's own statement that a mere glance to the right was what it took for him to realize that Cooper was in the back seat and he had forgot him, and then he pulls over into the little Mattio's pizza place. So then the question becomes, all right, is it reasonable to believe that you only glanced to your right that one time, in 2 miles, 2.5 miles, whatever it was? And it's a 6 or 7 minute, 8 minute drive, roughly. So is it reasonable, knowing that you've made right turns, left turns, probably changed lanes, had various red lights, been through, is it reasonable that that is the only time that you simply glanced to your right? And so if a jury doesn't believe that, then they don't believe his testimony.
While you're talking, I put up on the screen one of the shots of the inside of the car. This one shows the measuring tape. So this was done by the prosecution, but you can see the handle of the car seat there. So you can go ahead, they can get a visual there.
And from that same photograph, by the way, you see the computer bag, okay, in the floorboard, and there's other photographs that show the iPhone.
The light bulbs are right there.
The light bulbs there. There's other, and, we didn't ever see the light bulbs either. I wanted to see the actual light bulbs. Don't know why I wanted to see them. I just did. But there was also an iPhone charger in there. So when he got in the car, did he do like I do, like every single time, and plug my iPhone into the charger, which would require a glance to the right? So once again, if the jury did not believe his statement to Detective Stoddard that it was only that particular spot when he glanced to the right that he saw Cooper, then they could very well have disbelieved his entire statement, including the part about accident. So you take those two things together.
I'm going to share this one more time. They say they can't see it, so I'm going to put the picture up just one more time really quickly. I may have clicked on the wrong thing. Let's see if they can see that. Okay, so go ahead. Sorry.
Yeah, so in this particular photograph, you see the tape measure that was it basically measured the distance from the end of the car seat to where the radio knobs roughly are, in the sort of the center. I don't want to say console, but the control panel area there by the radio. And there's other photographs that were introduced that measured the distance between the car seat and the headrest.
Right. So right here at the end of this measuring tape where I'm putting the mouse pointer, right there is the handle of the car seat. Right. And right here would be his head. And I think that was probably a huge stumbling block for jurors to get past. Like, how could he forget? How could he not know he was right there?
We don't know. We don't know exactly where his eyes were. And if you think about this photograph that you have up here right on the screen right now, if you're walking to this car at 4 o'clock in the afternoon when you get off work at Home Depot, and you open the door and you got to put your laptop over there in the floorboard, right, and possibly plug up your iPhone to the charger that we saw stuck in the cigarette lighter in the front. Are you glancing to the right? We don't know where his eyes were, but we know that he put the bag there. So this, I believe, had to factor into the jury's decision that they just did not believe his statement to the police. If they had believed his statement to the police, they would have found him not guilty. So I think logic tells us that they just didn't believe what he had to say. Why they didn't believe it, I doubt that it was because of demeanor. I think it was because of logic, and they probably found some things that just didn't make sense, and they didn't believe him. There's a very strong counter argument to make that this is a guy who's so distracted with everything under the sun except his son that, he just was oblivious to whatever else was going on outside of his cell phone and his extracurricular activities. So that's why I say this is a historic trial, but there's always going to be an asterisk. There's always going to be people that won't believe it was intentional. How many people believe that Lee Harvey Oswald acted alone And so that debate rages and always will. And I don't know if this one quite will rise to that level, but certainly I think the analogy is an accurate one, that there's always going to be people that will believe it was an accident, and always going to be people that are going to believe it was an absolute heinous, malicious crime.
You're absolutely right. We have to jump to something else because the chat room is just blowing up about Leanna.
All right.
Taylor. They can't get enough of her. So I'm going to read the statement that came out today from her attorney. Because what she did, well, actually, what I should do is first read her statement. So she came out on Facebook and posted a statement about the verdict. And she's not happy about the verdict. And she's basically condemning anyone who is happy about the verdict and says, I hope it doesn't happen to you. I hope you're not one of these parents that this happens to. I have it right here. She says, for those of you who want to know that I'm okay, the answer is no. I have not been okay. Hang on one second. It just left me again. I have not been okay since the moment I was told my son was dead. I have not been okay since the moment my life was put on this path that has led to Ross being found guilty of maliciously murdering our child. So now you may be saying justice has been served, and you are allowed your right to that opinion. But guess what? You can convict every parent that this has ever happened to, and I can promise you two things. One, it will never bring our children back. And two, it will not prevent this from happening in the future. Next summer, as this begins to happen over and over again, ask yourself what can be done. The problem is not the parent. The problem is a society that refuses to believe this can happen to them! Exclamation point. Wake up! Exclamation point. Accept it. And by accepting it, you will be protecting your child. I don't care what your opinion is in my situation. I don't care what your opinion is of me. It does not matter. Your opinion will never bring back my son. So-called justice will never bring back my son. Nothing will ever take that pain away, and nothing will ever feel worse than living with the knowledge that his pain and his death could have been prevented. Be the wise parent and accept that this can happen, and you will never have to walk the path that my family's had to walk, and I pray you never have to walk this path. So she leaves that statement on Facebook, and everyone sort of blows up and goes at her. And apparently she's been getting horrible comments left about that. There's been so much talk when she was testifying about how she was, had a flat affect and didn't seem very emotional. We all saw that when she was at the police station right after this happened in the interview room with Ross, and they both acted weird, but she didn't have any emotion. So that's why all this is coming. So because of that, her attorney releases this, and I won't read the whole thing, but he says 2 years ago, after the horrific death of Cooper Harris occurred, the clouds began to swirl around Leanna Harris after her then husband was arrested. At that time, she was living every parent's worst nightmare and continues to do so every waking moment. Today, Cobb County prosecutor Charles Boring emphatically stated to WSB-TV that there is no evidence at all connecting Leanna to the death of her only child, Cooper. In fact, Mr. Boring reminded the public that we do not accuse anyone of crimes or jump to conclusions without evidence, of which in this case there is none whatsoever. So, and it goes on from there. It also says she took a lie detector test and passed it. So give me your thoughts on Leanna.
All right. So Leanna Harris clearly believes this was an accident. And if you start with that premise that it was an accident, Leanna's correct. Next summer, when it starts getting warm, we're going to start seeing more of these tragedies. We do every year. And it is important, as she points out, for people to understand that these things, this is a real thing. People do forget children in hot cars. It happens all the time. This was certainly not the first time. And so from that perspective, she's absolutely correct. From the perspective of the jury, apologize, I thought I heard my dog back there. People were asking about my cat. Now it's my dog. So from the perspective of the jury, who thinks that this was an intentional act, I bet the jury's saying, yeah, no, this is not going to be happening all the time next summer, because parents are not going to be purposely murdering their children by cooking them in the back of a hot car. So Leanna's statement is true, and it's also based on the premise that it was an accident.
Right.
So if you look at it from the prosecutor's perspective, they're like, yeah, no, I don't think this is going to be happening all the time. I tell you, other things might happen all the time. Armed robberies and burglaries, those happen all the time. This doesn't happen all the time. This happens once in my lifetime. I've seen it, and I don't think I'll see it again.
Yeah. I think you're right because, okay, we now need to work off the premise that he intentionally did this because that's what the jury says happened. I am still on the fence on the intentional. But how many parents are intentionally killing their children in that way? They're not. So we're not likely to see this case again. What's happening is parents are forgetting their kids in the car. That's what's happening. And that's the problem. Okay. So Chris from Canada says, when will Ross go to trial for the additional 8 counts? He has another indictment following this that many people are looking about. Answer your phone, Phil.
Oh, geez, I apologize.
He has 8 additional counts of, you keep calling it child pornography. Why don't you explain that to me?
Right, it's called sexual exploitation of a child, and that's what Georgia calls having a child.
His was with this trial too, right?
One of the counts, count 6, was criminal attempt to commit sexual exploitation of a child.
Okay.
Okay, and so that was because he had basically, I apologize. So anyway, my mother's trying to leave me a voicemail. Maybe I'll call her later.
Oh, no, Mom!
No. So anyway, so it's an attempt to go ahead and have this person who is under age, send a nude photograph or sexual type photograph. So she never did, although he asked for it. And an attempt is making a substantial step towards the actual completion of a trial. And criminal attempt is a crime in Georgia, and you have to basically make a good faith effort to complete another crime. And the punishment is half of what the crime would have been if you completed it. So in this case, it would have been 20 years maximum. In this case, it's 10 years because it's an attempt. So still a felony.
8 additional counts. They found more images and more evidence, right, during the investigation of this.
Yeah, we heard, remember, there's 2 witnesses that testified that the judge did not allow to be streamed or seen on camera. And one of them was the victim named in the indictment, okay? And she was the one who he asked to do, to take a picture of her and send to him, and that was the attempt. But there was another one that testified that she actually did send him something, okay?
And he wasn't charged with her.
No, but I wonder, is she? My guess is that she's probably one of the victims named in this other indictment. They used her as a witness in this case as well.
If you read the indictment, which you can find on Court Chatter, they redacted the names because they're minors, but they leave initials in place, which could also be fake initials. But either way, they're initials, and they're 3 different sets of initials. So that tells me at least that we have 3 minors.
Yes, yeah. So, in each particular instance, like if you had the same minor and you got 3 photographs from them, that's 3 separate transactions, so 3 different counts. So, unless any of those, if there's 8 counts in that indictment, and I haven't looked at it, there's some counts in that are misdemeanors. I know that because he's also charged with disseminating. That means sending information to a minor that's harmful. So, if he's got just 3, okay, that's another 60 years right there. Are they going to try him for that after they get a life without parole? I don't know.
That's what I was just going to say. I mean, at this point, he's facing. All right, go ahead. That's actually one of the questions. What's he facing, Phil?
Okay, so there's been conflicting reports, and really what it depends on is whether the judge agrees that some of these charges will merge, that is, blend together. So I'm going to go through the indictment. I'm doing it by memory. I don't have it in front of me, but I feel like I've got it memorized. So counts 1 through 3 are all murder and then 2 felony murders. Those 3 will merge together, okay, for 1 murder conviction.
Okay, somebody did ask me if he was facing 3 separate life sentences.
No, and in fact, counts 4 and 5, which are cruelty to a child in the 1st degree and then cruelty to a child in the 2nd degree, respectively, those would merge. Presumably, count 5 would merge into 4, and 4 would merge into 1. And because this is all one criminal transaction, okay, it's not separate events, and you didn't have separate victims. So you can be tried on individual charges, but when it comes time for sentencing, there's a concept known as merger, where some charges can be absorbed for sentencing purposes into another. A good example: if you're arrested for driving under the influence of alcohol, and part of the reason that you're charged is because you were failing to maintain your lane of travel. If you're convicted of the DUI or DWI as well as the weaving is part of what makes up the DUI. So it's technically separate offenses, but one is absorbed into the other. So you're going to have some of that. But what will not merge is the attempt to commit sexual exploitation of a child and the 2 misdemeanor counts of disseminating harmful material to a minor. So the murders will all merge. She can give him life with or without parole. She can add 10 years consecutive for the attempt to commit sexual exploitation of a child. She can add 2 more misdemeanors, 12 months each, by my math. And if my merger analysis is correct, and I feel like it is, that's potential life without parole plus 12 years.
Okay, because that's reported differently other places, but I believe you.
Well, and it's reported that way because it's reported in the media. I've seen several places today as 130, life plus 42 years.
That's what I was referring to.
And so I'm at life plus 12, so that's a 30-year difference, and that means that they're assuming that the cruelty in the first degree, which is 20 years, does not merge, and they're assuming that cruelty in the second, which is 10 years max, does not merge. So that accounts for the 30-year time difference, and I believe that those will be absorbed into the murder charges.
Is it a given that that's going to merge? I mean, is that just an automatic?
In my estimation, it's a given. I talked to this morning at breakfast. I was talking about this very issue with like 5 or 6 different criminal lawyers, and we were all in agreement that they were going to merge in that fashion. So I'm fairly confident that that's what's going to happen. Now, I've been wrong before, and I'll be eating crow right here with you probably on a live chat when that doesn't happen.
Okay, let's get to Jamie's question. Jamie wants to know if they ever showed the video of Ross leaving work for the day, walking through the parking lot, getting into his car and driving off. And that was something the jurors wanted to see. If that's something about him, could we see on that video him opening his car door, leaning over and putting his computer bag in? Did we get any detail from that type of video?
I don't recall seeing it that up close. What I recall seeing and what the prosecutor pointed out was that he literally gets in, closes the door, and within a matter of seconds scoots out of there.
And that's how I remember it. I remember that leaving for after work was boom, boom. There was nothing. There was like, get in the car, drive away.
But we did see that he had the computer bag in his hand, and we later saw the photographs of the computer bag in the floorboard on the passenger side. So
right, exactly.
You can infer from that he did lean over and put the computer bag down.
Right. Okay, let's get to some other questions. Lynn wants to, does Phil think that all the mental, I don't know what this means exactly, that Harris had throughout the day to remember Cooper, weighed heavily with the jury, like the reminders, like the cues, the mental cues, that's what she was trying to say. The mental cues throughout the day, do you think, we can say what we think the jury was thinking, we don't really know, but you have experience in trials and juries, and do you think that all those, what Lynn is talking about is he gets an email from Cooper's daycare. Now, we find out that's a standard email that comes all the time, and so he could have very well just not even thought about that. But
I get him every day, and I ignore him every day.
He texts his wife and says, are you going to pick up my buddy? That, for me, is a huge cue. That right there should have said, I didn't ever drop off my buddy. So we had some things going on that day.
Why would he ask her that question, just to play devil's advocate? Why would he ask her that question if he didn't think that Cooper was at daycare? So, so that it's one of two things. He's either trying to set up a defense to cover his tracks, If you're a cynic or if you're a defense attorney, you're going to say, if you're a defense attorney, you're going to say because he genuinely thought that Cooper was at daycare, which underscores our accident theory. So that cuts both ways. I never really saw that as a huge piece of this puzzle that really shed a lot of light on anything, because just like everything else, you can view it in at least two ways.
All right, several questions about the appeal. The appeal, is he going to appeal, and what's that process?
Of course, everybody's going to appeal a murder conviction, and it happens as a matter of right. He might stay with the same lawyers for the appeal. Generally, the practice is that a different defense team of one or two lawyers would take over the appeal, but he has an appeal as a matter of right. What's going to happen is he's not going to directly appeal the jury's verdict. What they will do, because there's no time to get a transcript together and to identify all the issues, you have 30 days to file an appeal. So what you do is you file a motion for new trial, and you tell the judge in very standard boilerplate language that there was not sufficient evidence and things like that. And then that preserves all of the issues for appeal. And then what happens is either current defense counsel, or if there's new appellate counsel gets appointed, they will later amend that motion once they have had time to digest this ginormous transcript, okay, and look for any things that they believe might have been error. And the reason that it's best practice to get a different appellate lawyer is because, and I mean no offense to the defense counsel in this case, I think they did an excellent job, but you want to have a fresh set of eyes to look at their work. You have a Sixth Amendment right to a lawyer, which means you have a right to effective assistance of the counsel. So an appellate lawyer, a fresh set of eyes, needs to look at what they did in this case. Did they make any mistakes that would deny someone of their Sixth Amendment right to a lawyer, i.e. an effective lawyer? So a new set of eyes is going to look at it, and they're going to amend the motion for new trial to allege any different numbers of errors, including any rulings on evidence made by the judge either before or during the trial. And there's literally hundreds of rulings. So they're going to look at each one of those and decide whether or not it would amount to a basis for a successful appeal.
So that was actually something I was going to ask about. I mean, in every case that I know of that we've covered on Court Chatter, the defense attorney never is the appellate attorney. That's always somebody else. But I have heard that Max Kilgore might. So you're saying absolutely not, or?
No, I'm not saying absolutely not. I'm saying probably not.
How often does that happen, that the defense attorney will continue on with the appeal?
Maybe 15% of the time. And yeah. It's not unheard of. And if the client is satisfied that that's not an issue, then they can, make that determination. In Cobb County, the way it works is that there are certain lawyers that are appointed that just do appellate work. And at this point, the defense team is appointed by and paid by the county. So they would have to be appointed and approved by we don't have a public defender system in Cobb County. It's called circuit defender. They actually appoint private lawyers because Max Kilgore has his own office. He practices with Carlos Rodriguez, and then Brian Lumpkin has his own solo practice as well.
Oh, thank you for that. So you guys don't have a public defender office. So that was because our trial watchers know what they're talking about. So they often ask, they're like, well, so what do you mean they're appointed, but they started out with these guys at the bond hearing? So, and then he was declared indigent after. So how did all
the GoFundMe page dried up? Okay, the money. Listen, I don't have any idea how much money these lawyers are making, but whatever it is, it's not enough because they had to shut down their lives for this trial. And there's not a person that I know of, and I hope that the point that I'm making is not lost on our audience here, is that everybody, I don't care who you are, you're entitled to a fair trial. Even the worst of the worst, because think about the alternative. If you weren't entitled to a fair trial, then the government could come after anybody even the the innocent people. So you've got to give the worst of the worst of the worst people a good fair trial. So that means having good lawyers. And so to get these lawyers to uproot themselves and go 6 hours away, to try this case over a couple of months, away from their practices, away from their families, they can't take in new business. They have employees, they have secretaries, they have other people that work for them they've got to pay. So whatever they make, probably not enough. But, it's a sacrifice that a lot of lawyers make, and they probably got a little bit more, if I had to guess, than the regular rate, and that's something the judge has some discretion to take care of.
Right. The judge does all of the funding, all the appointing of money when they need it for the experts or whatever they keep requesting.
And there's a standard rate that applies to felonies. There's a standard rate that applies to misdemeanors. It's much lower than you would get if you were retained privately. But judges can, in capital cases, and even though this wasn't a death penalty case, it's considered a capital case, the judge can order that their hourly rate be increased based on the complexity of the case. And, there has to be, they're just in the interest of fairness to the defense counsel, there has to be some allowances made for the change of venue and having to shut down their practice.
And then Mac wants to know, will he be paying for his appeal? Does he get, is it like one appeal that they get once they get a life sentence? They get one appeal paid still if they're indigent? That's
right. There's one appeal as a matter of right, and that goes straight to the Georgia Supreme Court on the murder case. It bypasses the Court of Appeals. Now, that appeal can take years. Okay.
Yeah, we know.
I had a trial that I tried against Chuck Boring a few years ago, and the motion, I lost it. He beat me, and it was a long trial. And it wasn't as long as this one, but it was a week and a half, maybe 2 weeks long. And there was a lot of pretrial motions, so the record was really, really large. And a very good appellate lawyer was appointed to represent him on appeal, and it was a year and a half before we had the motion for new trial hearing. And what happens is one side or the other will call the trial lawyer, in that case, me, as a witness. And if they allege that you were ineffective as a trial counsel, the prosecutor calls in the defense attorney from the trial as a witness for the state at that motion hearing, and they talk about your experience and your education, how many cases you've tried, how many cases clients you've handled, how many cases you've won, and they want to build you up and show that you're very, very capable, and that anything that you did that was questionable, was it a matter of trial strategy, or did you just screw it up, right?
We've actually seen a couple of those hearings where they put the defense attorney on the stand. We have seen that. Okay, let's get to Raylene. Oh, Raylene has a question about one of our favorite topics was you and I in this case was a 6-minute phone call to the daycare. So we get something. Yeah. So. She said, did we ever find out the details of that? So just really briefly, on the scene after Cooper's pulled out and other people are working on Cooper, Ross is on his phone, and witnesses and law enforcement say they can hear him talking. He says he never talked to anyone, never did anything. Now, phone records show he calls the daycare and that it goes to the toddler room. And there's almost a 6-minute phone call, but nobody at the daycare will admit to it. Ross says he wasn't talking to anybody. We waited and waited and waited for that. And who was he talking to? Who was it? And in the end, we didn't find out. And I think the defense did a good job of showing that it was probably nobody.
I don't know. It's a mystery wrapped inside an enigma. Okay, it's not a riddle. But it's something that when the dust settles, I'd like to maybe try to inquire with some of my friends about who were involved in this case, because it's obvious they thought that the teacher had answered the phone. Apparently, what we saw at trial, there was video of the outside of the. If only there were video of inside the toddler room, we would know. Okay, who answered the phone, if anybody. This is what I really think. I was so baffled by this, as you were, this whole time, because why wouldn't someone at the daycare just admit to it? And Kilgore made the point that you took Ross's phone, right? Right when he was talking and saying,
F you, I'm trying to call my wife, and whatever was going on, you took his phone and immediately cuffed him and put him in the back of the car. And then you had his phone, right? I think he was trying to get to that it was running, that the phone was just running at that time and that nobody was talking to anybody.
Yeah, it was just maybe an open line.
Right.
If I call your cell phone and it rings and rings and rings, is it going to ring for 5 minutes? I don't know. I mean, but the phone records, as I recall, from Home Depot said that the call came into the main call center and was routed into toddler room 5. So it wasn't like they just called the main number. It was actually routed into that room. So the idea there is that the phone was actually ringing, like you just heard mine ringing here at
Right.
home. Right. So,
do you think nobody was in that room and it just rang and rang? I mean, they say they had a camera outside the room in the hallway, and they claim that they saw the one daycare worker come and go, and so she would have been the only one inside the room. So I guess they would know. I don't know. I think it's going to remain a mystery until Phil gets us the inside scoop when he gets one of the attorneys to spill it.
yeah, if they, here's the thing I can tell you about this. Given this case, if they felt that this woman was lying about it, they would have charged her. If they felt they had evidence to prove that she was lying, they would have charged her.
And look,
They didn't charge her, so they clearly didn't think that she answered the phone.
The only reason to lie about it is if you've got something going with Ross Harris. There was zero evidence of that. Zero, none. And the reason they kept accusing the one daycare worker and bringing her back for more and more questions is they were just like, it has to be. You had to have talked to him because that's the only thing that makes sense. So they kept trying to get something out of her that just wasn't there to get out of her. I don't think she had anything going with Ross Harris. I think it's a mystery of whatever that phone did. But, they did hear him talking. I don't think we're ever going to know. All right, let's move on. Red just wants to know really quick for you to say that it will be the trial judge, Judge Mary Staley Clark, that hears the appeal, right?
That's correct. It's going to be the trial judge. Now, just with a side note here, I've seen situations where judges would retire or in some cases even pass away, in the middle of a term. I don't think that's going to happen with Judge Staley, but if this appeal goes on long enough and she decides, I'm going to go ahead and retire at the end of my term whenever it's over, and the motion has not been heard yet, it would be heard by whoever takes her place in that elected office. But short of that, it will be her, Judge Mary Staley Clark. Yeah, and she's still in her prime. She's not elderly. She's not in bad health as far as anybody knows, and we have no indication to suggest that she's going anywhere but right back to work in Cobb County. And I'm happy about that. I like her a lot. She's a great lady. I've had a lot of cases with her, and I'm just glad to see this whole crew back at home.
I'm sure they're glad to be back at home. Just a reminder, they were 600 miles away. Wait, 300 miles.
6 hours.
I was like 6 hours, 6-hour drive.
But there's no good way to get from Atlanta to Brunswick. You have to kind of go around your elbow to get to your ankle.
It wasn't quick to try and get there, and they all had to live there. And if they wanted to go home on the weekends, it's a mess. And so everyone put their lives on hold to get this done. All right, I think we are going to wrap this up. Right now in our live chat room on YouTube, quickly everybody say if you agree or disagree with the malice murder charges. It's the only ones we're really talking about because, maybe the criminal negligence was up in the air. The sexting charges weren't up in the air at all. I can't find anyone that was up in the air about that. So really it's just the malice murder charges. Agree or disagree? Start putting your comments in there, and I'll quickly just say, Addie says she's in love with the judge. And by the way, when your mom was calling, we got lots of hi, Phil's mom. We love your son. So maybe you should have just answered the phone, left it off the hook so she could have heard all this and we could have heard her. Okay, we have agree, disagree, agree. Oh. Shocking so far, for me at least. Although, I don't know, I kept feeling like everyone was so split on this. I just felt like they were so split on the malice charges that That's why I thought it was gonna be. I thought it was gonna be a hung jury, not just from my own personal, but from because this my job is the social media aspect of this. So between Twitter and our chat room with our trial watchers, that's that's where I was getting. I thought it would be a hung jury. That's what I was seeing from everybody that was watching this trial. That nobody could come to agreement on the malice charges. So to find 12 people that it appears they really didn't have a problem. I mean, in the end, it wasn't that long of a deliberation when they had so much evidence to go through.
Isn't that why we sequester the? I mean, in this not like they were in the hotel, but isn't that why the judge says don't watch this thing on the news, don't watch it on social media, stay away from any discussions about it, and just take the evidence from what you see in the courtroom and make your decision there? What if all this background noise that we're all exposed to for so long, what if we didn't have to hear that? Would it make it easier for us to focus in on the evidence from the witness stand and maybe make a decision?
You're so right about that. I say that every time going into a case with an open mind, and it's so hard to do that when you know so much more than the jury is ever going to know, quite frankly, because of all the pretrial hearings and you've read all of the motions, and it's so hard to say that you can put yourself in the jury box. I don't think any of us can put ourselves in the jury box because we know way too much about that. That's why I also never judge a jury. I don't. Look, I might be the only person alive that didn't judge that Casey Anthony jury either. So even though I think, I don't know, that's another story. So you just can't put yourself in their position. Look, they very well could have got the right verdict here. I'm not sure I agree with the intent. A lot of people do. A lot of people are still saying, okay, just so you know, Phil, Shara's in the chat room, and she says she introduced Phil to court chatter. So she's taking credit for that. Okay, all right, I'm going to wrap this up.
I honestly don't remember. Maybe she did. I don't know.
Actually, probably because Shar is addicted to court chatter. And Shar used to work in Phil's offices. Not for Phil, but in the same area. Okay, I'm just going to end this and wrap this up. I will end with Phil's remarks, but first I'll state mine. Another great case, an awful case. I hate saying great case. I say a great case because I'm such a fan of our legal system. And so that sounds horrible because there's a victim involved. In this case, there is just a darling little boy. And Cooper's the one that paid the price, whether it was an accident or intentional. The jury says it's intentional, so I guess it's intentional. He paid the price. He paid a horrible price. But this was a long time coming. This was 2 years to get to this case. And I thought it was a good, hard-fought case on both sides. A lot of times you don't have such great on one side or the other. I thought attorneys were great on both. I thought the judge was good. I don't necessarily agree with the verdict, but I don't care about the verdict because I don't care if he ever gets out. He's a creep. That's my opinion. And now I'm turning it over to Phil.
All right, so if you think about it, how many people just symbolically raise your hands if you assume that someone is guilty just because they've been arrested? Okay. When I pick a jury, I asked, that was one of the first, I say, when you walked in here, you looked at my client, and I just want to see a show of hands. How many of y'all just looked at him and said, hey, I wonder what this guy did? And 3/4 of the hands go up. So if you understand that there is a legal presumption of innocence, but as a matter of fact, there is a presumption of guilt that exists among prospective jurors. I don't care if it's a high-profile case or not. Most people, as a matter of fact, assume that if you've been arrested, that you're guilty. That is a known fact. And so defense lawyers have to remind them of their civics lessons and about things like burden of proof and proof beyond a reasonable doubt. Defense attorneys and the criminal defense team is always swimming upstream. So at the end of the day, whether the jury came to the right decision or the wrong decision is going to be something that's always going to be debated. But what will not be debated is that a very innocent, young, sweet life was lost, and that whether it was intentional or not, it was because of that child's father. And